So, the Utah Legislature has passed Bill 78B-6-503.5. Woohoo! This swanky new law authorizes the state of Utah to exercise eminent domain authority on property possessed by the federal government under certain circumstances. Very cool. So, now what? Well, in order to exercise eminent domain, the state will have to bring an action against the feds. This sounds like it might not be your typical kind of court case. How is Utah going to do it? What kinds of issues do we need to think about to give us the best shot at pulling this off? I'm Ross K. Moore, and this is Legal Blather from the nice folks at goodneighborlegal.com. This is the first video in a series that will offer some thoughts and ideas to consider as the state prepares to move forward on this bold action. First off, which court will this kind of case end up in? Many lawyers assume that issues surrounding title to land must be litigated in the state courts. I bet they're hoping to bring their first case against the federal government in a comfy, cozy state court with a highly sympathetic state court judge who will naturally side with the idea of taking back states' rights. Well, sorry. Nice try. Better luck next time. It's much more likely, like 100% more likely, that once Utah serves the action on the feds will simply remove the case to federal court. Can they do that? Yeah. And they pretty much always do. See, the federal government almost always removes all cases that name them as a party into federal court if that is an option. Well, is it an option? Yeah. See, any case that could have originally been brought into federal court may be removed to federal court, and it is solely the defendant's choice whether to remove the case to federal court or not. And in this case, the defendant is the federal government, and, well, they just tend to prefer going to their own court with their own rules of procedure and with their own big and powerful lifetime tenured judges. Go figure. But wait, don't issues surrounding title to land have to be litigated in the state court? Again, no. In a case brought under 78B-6-503.5, there will be two things going on that will allow for the case to be brought in federal court. First off, the case will be about a property which has a federal designation of status. That makes it a federal subject matter kind of case. Secondly, the case will name the United States as the defendant. There you go. That's all it takes. Pure and simple. So, even if the 78B-6-503.5 eminent domain case is filed in state court with a warm and fuzzy state court judge, that lovely judge will order the case removed to federal court just as soon as the federal government's attorney asks for it. And again, they pretty much always do, right along with filing a motion to dismiss pursuant to Rule of Procedure 12B. Too bad, so sad. Guess what else? They could even ask to have the case removed out of Utah entirely and send it to the federal court in D.C. Can anyone say, road trip to unfriendly shores? But wait, does that mean that the Utah Attorney General will have to plan and prepare the case differently because it will play out in federal court rather than state court? Yep, you guessed it. What do they need to be prepared for to be able to win in federal court? Well, those topics will be the subjects of videos soon to follow. But in the meantime, if this video was helpful to you, please share it with your friends in the Utah Legislature, the Utah Attorney General's office, and anyone else you think might profit from it. Thanks. I'm Ross K. Moore, and this is Legal Blather, a public service of goodneighborlegal.com.